We'll call the election law and municipal affairs committee meeting to order. And our first bill is House Bill 1695. I don't see Representative Lane. So, Vice Chair?
Mr. Chair, I'll introduce House Bill 1695, preventing any guide or explanation regarding the effect of a proposed constitutional amendment from appearing on the ballot.
Thank you very much. And
Senator Perkins Cook is a co-sponsor of this bill.
Yeah.
she is.
I should have done that.
Senator Perkins Cuoco, why don't you at least give us a brief on why you did this?
On why I co-sponsored.
We only have the Secretary of State, and if he doesn't have anybody before him to testify on, then this is going to be a real quick hearing.
Well, sir, I would like to say that I have more of a memory than I do, but I think that this is just intended to be kind of a cleanup and make sure that our voters and constituents can understand the change as clearly as possible that's being proposed. I don't know about you, but every election day comes and I get about 10 texts being like, how should I vote on these two measures? Because I think sometimes they're hard to understand. So I think it's just intended to be kind of a housekeeping bill.
All right. Secretary of State.
Morning, Mr. Chairman, members of the committee. Brendan O'Donnell, Deputy Secretary of State. Secretary of State's office doesn't support or oppose this bill, but did want to raise a few concerns with how it's written. So what the bill does, I think, is two primary things. One, it requires that the constitutional amendment on the ballot be displayed using strike through and bolding, the format that you're used to with bills. It also removes the language that allows voter guides, and that's not necessarily obvious. It's through that repeal and replace later on. The first concern is that requiring the entire provision of a constitutional provision with the both removed and added language to be printed is going to increase the size of the text on the ballot, which is going to contribute to overall ballot length. It's also going to make it, for I think many voters, harder to understand. There's just more text that they have to move through and understand both what is being removed and added. Second, which sort of pairs with the removal of the voter guide, even the bills that you get still have an explanation section for how to interpret strike through and bolding, and there wouldn't be any way to explain, and it would be, I think, a large lift to educate voters as to what strike through even means when you're reading a provision like that. You also have, in terms of, and this bill's an example, you get to certain amendments, in the last one regarding the voter guides, it's written as repealed and reenacted, in part because it would be very difficult and wordy to put all of the removed and all of the added language in the same spot. So sometimes it is just cleaner to say, amend this provision to read as follows. Finally, just in terms of having the ability for a voter guide, as you all know, sometimes there are words that have complex legal meaning that extends beyond the ordinary understanding of the word. Those are opportunities where the state, through the legislature, should have the flexibility, if needed, to have a voter guide to explain what is the actual everyday impact to you by changing this word that means a lot more than you think it does. So there's just some of the things we wanted to raise for the committee. Happy to take any questions.
As I remember, the statute now says that if we're going to add something to it, it's supposed to be in the bill as it's passed by the legislature. Is that still the way it is?
That's the way it is currently written, and this bill would remove that. So under 663(3)(a), the text of the statement for the voter's guide, if any, needs to be included in the resolution proposing the constitutional amendment.
Further questions from committee members? Seeing none, thank you very much. That's the last person who signed up to vote. There were 32 in support and 10 opposed on the online, and with that, we'll close the public hearing.
Move to go into executive
I have a
session.
motion to go into executive session. All those in favor say aye. Aye. All those opposed say nay. The ayes have it. This bill, because the legislature is the one who picks what goes on that, and with the other confusions that the secretary put out, I am not in favor. Anybody want to talk before we take a motion?
I just find in line 12 and 13 on the bill kind of interesting. If it proposes a constitutional amendment in which the Constitution will be amended, kind of seems redundant. So this language of the bill is kind of awkward.
All right, I will move ITL.
Second.
Any further discussion?
Yeah, I mean, I hear the arguments. Perhaps there's some work we could do to clean this up, but I also think, given the likelihood of a constitutional amendment passing this year, we also could work together to try to get this right for next year.
If you would like me to rescind my motion and make a motion of interim study, I would accept that.
Okay.
I will rescind my
I'll do
motion.
the second.
Rescind the second. Senator Burton Coca.
I will move interim study so we can work together to get the wording right on this.
Okay. And I will second. Any other discussion? All those in favor say aye.
Aye.
All those opposed say nay. The ayes have it. Any objection to consent? Seeing none, all those in favor say aye.
Aye.
All those opposed say nay. And
I can take it out.
okay. All right, and our stack of bills, we've got a bunch of them that I think we've written amendments to. If I take 1021, this is the amendment that was worked out after the meeting last week. I did send a copy to Mr. Michaud. I got no comments back from him, and I believe that it takes care of his problem with the wording about last year, this year, and puts the date at April. So I will move ought to pass.
Second.
And I will move amendment 1532S.
Second.
Okay, further discussion? Seeing none, all those in favor of amendment 1532S, say aye.
Aye.
All those opposed say nay. The ayes have it. Bill as amended. Discussion? Seeing none, all those in favor say aye.
Aye.
All those opposed say nay. And is there any objection to consent?
Nope.
Seeing none, all those in favor say aye.
Aye.
All those opposed say nay. And I'll take that one out.
You want to do 1131? I have an amendment for that one.
You sure? 1131.
So you should have an amendment in front of you. This is the whole discussion on where to put the request for second SB2.
Why don't we take the hot pass motion from you?
Sure.
Because you're talking to the
I'll move.
amendment,
I'll
so
move
I wanna
OTP.
get to the amendment.
I'll move OTP,
Okay, and I'll second.
and I'll move amendment 1553S.
1553S.
And the amendment strictly does that, considering that traditional town meetings use a traditional town format, this will maintain that if you want to go to SB2. However, we'll require that an SB2 vote be first on the list of town meeting requirements.
I agree. I think that'll be the least intrusive way of doing this. It gets it up there, handles most of the complaints that we heard without using the new system to invoke the new system. And the Secretary of State, when I said I wanted to put it on the November ballot, he was not happy with it. All right, further discussion. The amendment is 1553S. All those in favor say aye.
Aye.
All those opposed say nay. The ayes have it. Now the bill as amended, discussion. Seeing none, all those in favor say aye.
Aye.
All those opposed say nay. Is there any objection to consent? Seeing none, all those in favor say aye.
Aye.
And
I'll take it out.
Senator Lang, take that one All right, going down numerically, House Bill 1187. I will move OTP,
Second.
and I will move Amendment 1555S.
Second.
Okay, we have a second. This one here, this is basically what we had talked about in committee. Get down to, it changes the 3 days for 2 hours into, if they provide notice of who can accept them, arrangements can be made. That way, somebody who is still working a 40-hour shift wasn't there during any of those 3 days or 2 hour periods during those 3 days could still get their, should still file for the position. Any further discussion on the amendment?
I just want to add, thank you, Mr. Chairman, for drafting this amendment. I think that the towns affected by this scenario defined, I definitely have probably more in my district than any others where we've got limited town clerk hours, and I think this is a reasonable amendment, and I think this would accomplish what we're trying to do here. So, thank you.
All right, further discussion? Seeing none, the vote is on Amendment 1555S. All those in favor say aye.
Aye.
All those opposed say nay. The ayes have it. Now the bill as amended. Further discussion? Seeing none, all those in favor say aye.
Aye.
All those opposed say nay. Is there objection to consent? Seeing none, all those in favor of consent say aye.
Aye. I'll
All
take
those
that one.
opposed say nay. And Senator Rutherford will take that one. And we're right up against the time, so we have a motion to come out of executive session. All those in favor say aye. Aye. All those opposed say nay. We're back in regular session, and our next bill is 1184. My watch hasn't changed to the end of the hour yet, so settle,
Okay.
get down, settle,
All right, okay.
and get ready, and
Okay, I can,
yeah,
You've got 1 minute.
we don't make you stand.
thank you. That's these ones.
Thank you.
If you could pass those around, if you will.
Oh, we got a sizable list on this one, and everybody wants to talk. Okay, it being the appointed hour, we'll open the hearing on 1184, and prime sponsor for you to introduce the bill and yourself.
Sure. Thank you very much, Senator, and esteemed members of election and municipal law. I'm just introducing House Bill 1184. I'm Juliet Harvey-Bully. I represent Belknap County 3. And this bill will establish a process for issuing, extending, and appealing no trespass orders for municipal and school properties. Doesn't pertain to private property. And establishes procedural safeguards for individuals affected by these orders, including the right to a hearing and appeal. This bill's second go round. Last year, the Senate CJ committee passed a stricter version of the bill, and unfortunately, it got Christmas treed and failed in the committee of conference process. But simply put, this bill, we don't have a process now for people who have been issued no trespass orders on public property. It's a process of redress or due process. And so when somebody gets issued one of these no trespass orders at a town or a school, it's essentially the same as if they were on private property, and you can just ban them forever without the aggrieved knowing they're their appeal process or how to appeal. I just wanted to point out that if you go to the zoning board or a land use board and you have a decision, then that person that's issued a decision for their application or case, they get a notice of decision, why it was made, and how to appeal. That's at the bottom. If you get a speeding ticket, at the bottom of your speeding ticket, there's a process for appeal. However, if you get one of these no trespass orders, chances are there won't be no process outlined for you. So this has come to pass because there's been several problems, several of these sort of cases and incidents that have happened in New Hampshire. And I've given you a chart here. It's double-sided with examples of incidents that have happened in New Hampshire. And I just want to break it down. I'm not going to go over all of them. But there's four basic types. There's sort of the harassment that I assume all the law enforcement in here they're going to speak to, where you could have a dangerous situation or somebody may be threatening violence, and that's we take very seriously. But then there are opinions. And so you'll see here, for instance, under Hampstead, it could be a school board member with an unpopular opinion, and they suddenly find themselves with a no trespass order. There's several examples of this, different types. And then there are personal conflicts where it could be somebody's ex who is working in the school, and they just have a conflict. They don't want that. They don't want to see their ex there. That's actually happened. And so that person also has a no trespass order to deal with. So it's very loose. And then the final thing is a category is what I'll call a wrong place, wrong time. For instance, I'll use my poor daughter as an example. She went to the beach down in Belmont, and she was there after hours with her friend, and a cop, came and said, "You're being no trespass out of here. It's after hours. You shouldn't be here." But he said, "Don't come back." And so they haven't ever come back because they don't know they don't want to get caught coming back to a beach because they were told not to come back. What I think he meant was don't come back after hours or don't come back this week or something. But because the verbal no trespass orders are so vague, then you're left with, I'm not sure what that really means. Is it still in existence? So that is why we're hopefully putting in place a written process here, which outlines, the clear explanation for the NTO, the duration of the NTO, and a statement, and how to request a hearing. And so this is what we have here from the House committee. And one final point here is just that you'll hear, from those after me, they'll say, what we're worried about is dangers to the towns because you could have somebody who is violent, which is definitely a concern. We don't want any of that. But in some of these cases, what we really need is for them to pursue a restraining order. And you'll hear that, maybe that's so, but we don't like the idea of it. But that is certainly an avenue for them. They can get a restraining order within 24 hours if there's a serious threat. So, but most of these incidents that I have here are not. Some of them are long-standing. They could have had a personal conflict with somebody, and then it's been years since they've been allowed to, say, use the town dump. Or they weren't allowed to vote in the case of Hampstead, where the no trespass order was so vague that they had to ask for permission to use the school to vote. So that's what we have.
Questions
I'll
from
take some
senators?
questions.
See.
Thank you. So I'm just looking at page 1, lines 18 and 19. So the emergency no trespass order shall be effective immediately. Just want to make sure I understand this. But shall expire automatically no later than 72 hours after issuance. So the emergency no trespass order is given it's for 72 hours, and then that triggers lines 20 through 23, where the governing body then has to meet and get a 3/5 vote to extend it after 72 hours. Are we concerned that the governing body, is that too short of a time? I mean, I'm just thinking, can the governing body convene? You know, are there people, I mean, can you get a quorum? I mean, I'm wondering if that's too short of a time to get that governing body logistically back to take that 3/5 vote.
Thank you, Senator, for the question. So I was on a governing body, or I am on a governing body with the county. We had an emergency meeting. We called it within 48 hours.
Okay.
It can be done. It's in our legal framework. We just put it out, and it's an emergency meeting, and it was actually challenged in court, I believe, and we prevailed. So it was, yeah. So it can
Okay.
be done.
All right.
Thank
Further
you.
questions from the senators? Seeing none, thank you very much.
Thank you.
Representative Barton?
I'm waiting for some written paperwork from upstairs. I'm happy to yield to any other until they bring my copies down for you.
All righty. Bissett, SAU. We are going to have a 3-minute time limit today. Prime sponsor gets exemption from that, but the rest of you, 3 minutes.
Good morning. I don't have a prepared written statement for it. I'm coming today because
We like it that way.
I know I've heard you before when you said that. My concern here as a school educator, I'm an assistant superintendent for the Kearsarge Regional School District. And in 2026, we had a convicted sex offender that made very public news, if you will, who was on our campus multiple times, photographing and videotaping students. You can check the MUR for the details of it. After that experience, in which we found that the courts had allowed this person to come on our campus for a period of time between his conviction and his being jailed, I learned an awful lot about the system of convicted sex offenders and how they make it to the registry, what happens when they get to the registry. It's after, by the way, that they're released from incarceration. So as a school leader, I don't have the ability to understand or know when convicted sex offenders are in our area or in our communities per se until they make it to that area. To that list. Sometimes they don't check in, by the way. There's recent news you can see in MUR that's spoken to that particular issue. I wrote a policy for our school district, which is probably the only one I know of in the state right now. I worked with the NHSBA, I worked with lawyers. I crafted a policy that requires criminal sex offenders who are in our 7 towns in Kearsarge to have time, place, manner restrictions as to how they can potentially be on our campus. They are not allowed to be on our campus at all without a notification to the superintendent or designee that allows for that individual to be in a position where they will create a time, place, manner restriction plan that allows them to attend FERPA protected rights activities like an IEP meeting or such, but they are not allowed to go to a school play. They're not allowed to be at a sports event. Those are very hard places to manage. I'm here today because I need to ask you to put a very narrow carve out. I'm not here to debate the practice of whether or not this is a First Amendment right. I need a carve out, an amendment to this that specifically carves out restrictions for criminal sex offenders who happen to reside within our communities so that I can enforce this policy with trespass. I need to prohibit these individuals from coming on our campuses, and I don't have time to wait 60 or 90 days for a hearing to take place with a school board, which sometimes takes quite some extended time, 2-3 weeks to organize a quorum in 7 towns. And I need that ability to work with that 3 times a year. So I'm here to, I propose some amended language. I've sent it to, I've sent it to Senator Lang. I think he has a copy of a proposed amendment that would qualify to expand that opportunity for us in public schools. I will also tell you, I'm very concerned. I'm very concerned about the fact that the only recourse that we as superintendents have is trespass when we have individuals with firearms that are on our campus. We initiate lockdowns and then we rely on our local law enforcement to remove those individuals from our campuses under trespass.
Questions from the senators? Seeing none, thank you very much.
Mike, I didn't get that email yet, so you might want to try sending it again.
Okay, thank you.
NHAC, Barbie?
Good morning, Chairman Gray and members of Senate Election Law. My name is Kellen Barbie with the DuPont Group on behalf of the New Hampshire Association of Counties. For the record, the NHAC is opposed to HB 1184. This bill allows for emergency no trespass orders that last 72 hours. To extend the order, a public hearing and vote by a governing body are required. This hearing must be noticed at least 24 hours in advance, not excluding Sundays and legal holidays. This creates a clear problem. If an emergency order is issued on a Friday before a long weekend, the 72-hour window will expire before a legally compliant hearing can be scheduled and held. At that time, the order simply lapses, regardless of whether the threat still exists or not. This also raises real public safety concerns. Nursing homes and correctional facilities rely on clear and consistent authority to manage safety risks. This bill undermines that by creating unavoidable lapses in coverage. Finally, this bill significantly expands the scope. It now applies broadly to public property, which likely includes municipal, county, and state property, and also uses the term governing body, which varies widely among entities. This creates inconsistency and confusion about who is responsible for acting, affecting how quickly they can do so. In addition, because there are only 3 county commissioners, the 3/5 requirement would be impossible to meet for them. In short, HB 1184 creates a procedural conflict that makes compliance difficult, introduces risk to public safety, and expands its reach without sufficient clarity. For those reasons, the NHAC urges the committee to find the bill an expedient to legislate. Thank you.
Questions from the senators? Senator Provoca.
Are you aware of data or incidents that's leading to the bringing of this piece of legislation? I know the prime sponsor spoke to that, but I'm just wondering for other perspectives.
Not off the top of my head, no.
Okay, thank you.
Further questions from the senators? Seeing none, thank you very much.
Thank you.
New Hampshire School Board Association, Mr. Christina. Just to remind people, we are on a 3-minute timer.
Thank you very much, Chairman Gray. Good morning, members of the committee. Barrett Christina, New Hampshire School Boards Association. We are opposed to House Bill 1184 as it is currently written. Part of our concern, Senator, you mentioned the 72-hour timeline to notice and have a meeting taken under the right to know law to extend the no trespass order. We think that is unreasonable to try and get a quorum of a board together within 72 hours, especially in certain over school vacations or summer months, just may be impractical and maybe not possible. We might recommend that rather than within 72 hours, perhaps language could be added to state at the next regularly scheduled school board meeting or something within 30 days of the issuance of the no trespass order. That might be a little bit more reasonable. We also have concerns on page 1, line 21, that the vote has to be to extend the no trespass order as a 3/5 vote taken. Every other vote in a school board meeting is a simple majority. I'm not sure why this should be a super majority. We would request that be amended to say just a simple majority vote taken. Also, I guess the third concern that we have is that on line 24, the NTO cannot be authorized by the school board for no more than 90 days. So if the alleged behavior was egregious enough that the school personnel and the school board felt that this individual may be a threat or a danger to staff safety or student safety, having to re-up that every 90 days, we don't think is necessarily reasonable. I understand the desire to have a timeline on the NTO, but we think it just sort of off the top of my head, maybe 365 days or 1 year for an NTO to be issued, but perhaps after 180 days, the individual could request that it be revisited. And I guess Page 2, lines 12 and 13, again, if the individual requests a hearing before the school board, the hearing has to be held as soon as possible or as reasonably possible, but no later than 15 calendar days after the receipt of the written request. Again, we would respectfully request that that be extended to, again, language that says either the next regularly scheduled school board meeting or within 30 days. So I think that concludes my testimony. I'm happy to answer any questions.
Questions from the senators? Seeing none. Oh, Senator Lang.
Public hearing notice required for a school board meeting.
24 hours under the right to know law. But notice has to be posted within 2 places, one of which may be the internet website. I do understand the representatives talked about an emergency meeting. An emergency meeting means where action is imperative and immediate undelayed action is imperative as deemed by the board chair. So, if depending on the nature of the allegation that leads to the issuing of the no trespass order, an emergency meeting could be held. It's also important to note, though, that the quorum requirements for an emergency meeting under the right to know law are waived. So if you had a 7 or a 9 member school board, you have an emergency meeting, you might only have 2 or 3 people there which would be issuing the no trespass order. I don't know if that would be reasonable as opposed to a 9-member board hearing the facts and the issue and the matter before the board. Thank you.
Additional questions, Senator Burke? Go ahead.
Thank you for your helpful testimony. Can you just clarify for those of us less familiar with this procedure? I mean, what would happen without this if someone was found on school grounds, shouldn't be there? Like, wouldn't it just be a matter handled by law enforcement or?
Thank you for the question,
Yeah.
Senator. Not necessarily. I presume that it would only be a matter handled by law enforcement if there was potential criminal activity.
Okay.
I can't speak anecdotally to one situation that with the school board that I wasn't personally involved with, but helped the school board and the administration deal with a number of years ago. There was a custody dispute between a husband and a wife. It was actually out of state. The family lived close to the border, but it was in Massachusetts. The father lost custody of the children and went from the courthouse straight to the school to potentially abscond with the kids.
Yeah.
The principal called the law enforcement and the law enforcement officer told that building level principal, I cannot do anything unless you issue a no trespass order. There was at that point, there had been no crime allegedly committed, no allegations of a crime being committed, but the person was irate, angry, arguing, trying to walk through the school. So they had to issue the no trespass order in order to, I guess, sort of invoke or start potential criminal processes if the NTO was violated.
Wow.
Additional questions?
Okay.
Seeing none,
Thank
thank
you.
you very much.
Thank you.
From NHMA, Sarah Burke Cohen.
Good morning. My name is Sarah Burt Cohen. I represent the New Hampshire Municipal Association. We oppose HB 1184. I won't go into detail. I've given you some written testimony. A few things I'd like to touch on. So if you look at 635:2 currently, it is the criminal trespass statute. So essentially, a criminal trespass is the civil matter, which is the no trespass order has to be issued before anything further can happen. So that's something to think about as we move forward. Putting in this other more burdensome process is sort of duplicative of what happens already in 635-2. Additionally, a no trespass order can be appealed to the Superior Court if someone agrees with it. And additionally, a public entity could already go get a restraining order against an individual if they thought that it needed to rise to that type of thing. Something else to consider is the 72 hours. It's been talked about. This is inadequate. What happens in that 72 hours if the governing body cannot get together and the 72-hour, the no trespass order expires? It escalates, the individual escalates and goes back to the public property and does property damage, public safety issues. is the person, can you issue another 72-hour no trespass order? If not, because it's the same individual, what happens? Does the individual not get a no trespass order? What does that look like? How does that work for municipalities and their municipal employees? It does create somewhat of a safety risk. Additionally, most municipalities have delegated the authority to sort of have keep in mind the safety of their property, employees, and public to individual municipal employees. So these employees have the trust of their governing body. This essentially asks for the governing body to potentially vote for a no confidence in their municipal employee who's issuing the no trespass order. This can be problematic for morale for the entire staff of a municipality. Also, something to consider is, just went out of my mind. That's
30 seconds.
I know, and it's gone out. So I'm going to just defer to my written testimony because I lost it, and I'm happy to answer questions.
Questions from the senators? Seeing none, thank you very much.
Thank you.
NHLA, Van Zanter.
Yep, I always forget that. Good morning, Senators. My name is Denise Van Zanten. I am the director at the Manchester City Library, and I'm also here in the capacity as president of the New Hampshire Library Association, and we are opposed to House Bill 1184. I have sent you my written testimony ahead of time, but I just want to read for the record that this bill infringes upon local control and interferes with the responsibilities and policies of our duly elected or appointed municipal town and library boards. Libraries already have processes and policies in place to deal with denial of access to our buildings or services when warranted. Our police departments cannot always respond due to emergencies, and thus library staff may have to step in and issue the trespass in order to deal with the situation in real time. Further, during these interactions, the individual may refuse to give their name, address, or accept any written materials to comply with the letter of this proposed law. Some of the behaviors your librarians unfortunately deal with in our buildings are intoxication, drug use or sales, physical assault, threatening of another library visitor or staff member, theft of library materials, fighting, domestic situations, damage or library property, public urination, and public exposure. While these events don't happen regularly, they do impact our services, and we need to be able to address them as the event is happening. For those who are not on the front line in public buildings, who have never been threatened or dealt with a person who is irate or inebriated, you cannot know the trauma such interactions have. This bill is taking away a very important tool for us all to keep our buildings safe, and local control should set the procedures instead of one size fits all.
Questions from senators?
Thank you, Mr. Chairman. Thank you, Denise, for your testimony. Does the city of Manchester have a form filled out with police to trespass people from the library?
We have one with the police department, but we also have our own procedure in place with a process to be reinstated at the library.
Okay, and then follow up, if I may. In your opinion, would this not allow the form with the police?
I don't know, you'd have to ask the chief that, but I do know it's going to impede on us. If someone has an incident at the library on a Friday and we call the police and they issue the trespass order, is it going to be my library board of trustees who oversees the review of this? Or is it going to be the board of mayor and aldermen? So there's some confusion.
Thank you.
Additional questions? Senator Lang?
So I guess my question is, are you just objecting to it's only a 72-hour order and without another vote of a governing body?
We are opposed to it being put forth by the state. We feel it belongs at the local level, and each library specifically should be able to set the rules based on our communities and our needs.
Save the rest for police.
Additional questions? Seeing none, thank you very much.
Thank you.
Representative, we're back to you. And remember, we have 3-minute limit.
3 minutes. Good morning, Senators. I want to say first, I'll give you my opinion on the 72 hours.
Need to state your name.
Representative Joseph Barton, Grafton, District 1, Littleton, New Hampshire. I think there's not a clear distinction between what a no trespass order is and what a temporary restraining order is. And that's confused by a lot of people here and a lot of testimony that I've heard. A no trespass order, I can get one against you, any one of you, for no reason whatsoever on my private property. This is public property we're dealing with. Okay, so when it comes to public property where I may have a right to be, such as a polling location, if I was a polling challenger and maybe the town moderator doesn't like me, they can issue a no trespass order and that person is gone. This is no trespass orders for municipalities has become a weapon, not a tool to protect the individuals. If there is a legitimate safety concern, you got a 72-hour window. You can get a TRO, and then you can go through the due process of the court system there. If you just want to, this allows for a no trespass order on a public property and mechanisms by which members are protected. And in my case, I found a safety violation at my daughter's school. I made an issue of it. I documented it, and I was issued a no trespass order. So I couldn't come on my daughter's school and document anything further. So the no trespass order in this case was retaliatory. No reason was given here. There's no reason here. So I had to go to the State Board of Education, say, hey, I need due process. They need to give me notice. And the State Board of Education says, yes, we do. So 6.5 months later, I finally get a hearing to address this so I can drop off my daughter to school and pick her up. She is on an IEP, and it has impacted her education significantly, and it's caused me harm because now I have to drive another 12 miles to go to an IEP meeting, purely because this has been a weaponized punitive tool. I want to note in right to know requests, I got emails between the superintendent who weaponized this no trespass order and the local PD who kind of collaborated together, and they were talking about House Bill 143, which mirrored this. It was passed, but what was passed, there's a replace all amendment that completely changed the legislation to something that I wouldn't even recognize, but they thought that they had to follow that. So, it's become weaponized. I don't get due process. I have 2 lawsuits. I have to go to court just because a superintendent weaponized a no trespass order against me. I have a bunch of stuff to pass out, mostly from right to know requests and whatnot, and I'm happy to take questions.
From the senators? Seeing none, thank you very much. All right. Are the two of you coming up together, or are you coming up separate?
We can't come together.
Just scoop one of the chairs up.
Chairman and members of the committee, thank you for the opportunity to speak today. Thank you for the opportunity
You
to speak
both
today.
need to state your names.
My name is Peter Marr, and I'm the Chief of Police in Manchester. I'm here to respectfully oppose HB 1184 as currently written. I want to begin by acknowledging the intent behind this bill. Ensuring fairness and due process is important. However, from a practical operational standpoint, this legislation creates significant challenges that will make it harder for municipalities to maintain safety on public property. I'll also say this candidly, this bill appears to be a response to a specific incident or incidents rather than a widespread or systemic problem across the state. In my experience, there is not a pattern of misuse of no trespass orders that would justify this level of statutory restriction. What this bill does is attempt to solve an isolated concern by creating a broad framework that will have unintended consequences in communities like mine. In Manchester, we issue no trespass orders regularly and for good reason. These situations arise in places like City Hall, the public library, and on school property, often involving individuals who are disruptive, threatening, or there for clearly inappropriate or unsafe purposes. These are not theoretical situations. They are frequent, real-world incidents that require immediate and sometimes sustained action to protect the public. This bill shifts the burden away from the individual whose behavior created the issue and places it squarely on the municipality. It requires repeated justifications of decisions that are already based on observed conduct, and it introduces procedural hurdles that may discourage officers and officials from acting when they should. This 72-hour approval requirement is particularly problematic. In Manchester, our governing body is a board of mayor and aldermen that meets twice a month. The school board operates on a similar schedule. If a no trespass order is issued on a Friday, you immediately run into the weekend. If Monday's a holiday, there's no realistic path to getting the order approved within 72 hours. The result is that the order simply expires regardless of the risk posed by the individual. That is not a policy decision based on safety. That is a failure of process driven by unrealistic timeline. Requiring a 3/5 vote at a duly noticed public meeting only adds to the problem. It introduces delay, administrative burden, and in some cases may require discussing sensitive situations in a public forum. I also want to highlight that the bill relies on the term governing body without clearly defining it. In New Hampshire, that varies widely depending on the municipality and the school district structure, which will lead to inconsistency and confusion in how this law is applied. In practice, this bill will not improve safety or fairness. It will make it more difficult to respond effectively to ongoing issues. It creates a system where access to public property is restored not because behavior has changed, but because a deadline could not be met. If this bill is to move forward, I believe it needs significant amendment, particularly around defining governing body, extending the emergency time frame, and allowing for administrative approvals that reflect how local governments actually operate. In closing, we all support due process, but this bill, as written, risks creating a system that prioritizes rigid procedure over practical public safety and community concern. Thank you for your time.
Officer?
No, I was just going to reiterate what the director said.
Okay.
I just here for any questions.
Questions from the senators? Senator Lang.
Can you walk me through pragmatically what an NTO looks like from beginning to end? When we'll use the library because they testified, so we'll use the library as an example. The librarian calls the police and say they have an unruly subject, a subject urinating in the book stacks, whatever the issue is. What's the process? What happens with you guys? How do you get to an NTO? What's the follow-up process for that NTO? How long is that NTO?
We would go make contact with the person that they want removed, speak with the staff over there, and then if they want them removed, we would remove them. If they have a form that they would fill out, the duration of it, we would leave that up to them.
So they're not charged with anything at that point. They're just removed from the building.
They could be.
Well,
Again, like establishing the probable cause for the crimes, yes, we could take action if that was necessary.
Length of time for the NTO is left to the discretion of.
We would ask them what they would like. Generally, we do for a year if there's a significant problem.
How's that process differ from a private individual who owns a convenience store and someone shoplifts and they go, I don't want that person back in my store ever?
It doesn't vary very much. It's pretty much the same process. They would be noted that they're not able to return.
And then if they do, you would charge them with criminal trespass?
That's correct, yes.
Additional questions? Senator.
Thank you, Mr. Chairman. So on line 21, my question is, the governing body shall approve the NTO by at least 3/5 vote taken. And it appears that, like in Manchester, the BMA, if 8 people showed up, you still need 10 votes. So 8 people would not be enough showing up because it says the full body and not those present.
That's how I
Correct.
read it too, sir.
All right, thank you.
Yes.
So I guess the question I ask is that, should it be different from private property, which the owner has the rights and can throw anybody they want off, and public property, which is we're all the owners of that property, and someone has a right to be at a park, but for whatever reason you're taking that right away? Should that process be different because of the type of property it is?
Yeah, I don't disagree with that, sir. But I think setting up a proper framework to make that possible. I just think 72 hours is I don't think anybody can.
I don't disagree with you on the 72 hours.
No, I do think that because it is public property and people, that's definitely different than private property. I do think that it shouldn't be weaponized. I can say, I don't believe that any of the ones that we've given out in Manchester have ever been weaponized. And we actually err on the side of constitutional rights, and we're always worried about liability and putting the city in a bad situation where it gets sued for violating someone's rights on public property. So we take that very seriously. And again, that's kind of, to my point, is I think this is a few isolated incidents that have affected or is going to affect the entire state and how it takes place. I would be happy to work with anybody as far as, setting up a framework for that but I think we need to pull in, place, smaller towns, larger towns, and we need to make something that works universally for everyone. And I do think there should be some sort of due process where you can argue your side of events.
Thank you.
From the answer to that, it would appear that there is no requirement for any due process statement that this is how you would appeal on the NTO at present. Is that correct?
I mean, you would handle it just like a civil, any sort of civil action. You would go and even either sue that.
But there's no notice required on the NTO.
Not in Manchester. I can't speak for other.
Okay. Thank you very much.
You're welcome, sir.
Eric.
Thank you, Chairman Gray and members of the committee. For the record, my name is Eric Power from Brookline. I'm the president of the School District Governance Association and in support of this bill. What we have in New Hampshire with no trespassing orders is sort of the Wild West when it comes to public property. Private property, you can make a permanent no trespassing order on your property for a person with no reason. But when you want to when there's public property, the public has a right to it unless they do something that requires them not to. But it shouldn't be an open process when it can be forever, years. I have a neighbor that has a no trespass order that's for the transfer station, and it's still going on. It's almost 4 years old. That's not really right for just an argument that happened there 4 years ago. There is, this is a bipartisan amendment that came out of municipal and county government committee. This is really, if you're trying to do an emergency NTO, that gives you 72 hours. That's plenty of time. And I know they had debated 24 versus 48, but that's plenty of time to get a temporary restraining order. Or you can call an emergency meeting of the governing body. And governing body is a very well-known term in RSA, as you know. A 3/5 vote is, there was consideration of having that being a unanimous vote because you're trying to deny somebody their rights to property. It should not just be, there's a standard of beyond a reasonable doubt. This approaches that. So I think that's reasonable. Putting a 90-day limit on a temporary, no trespassing order makes a lot of sense. Because it shouldn't be forever. And right now it's completely open, and that's a problem, especially against public property. There was some talk here about, I think we're conflating what a no trespassing order is and what a restraining order is. The right tool for a lot of what you have heard today is a temporary restraining order or a permanent restraining order. For a sex offender, for somebody who's a habitual offender, no trespassing order isn't the right tool. The no trespassing order is a limited tool for a limited situation. And right now it's completely open. This is a problem across the state, both in school districts and in towns. And I was a former school board member, and I would like to know if somebody in our school district has issued a no trespassing order, and that's not always the case. And this requires us to know that that's actually happening. Also, I would like to be able to have knowledge of it so that we could actually see what was going on and understand. And for those reasons, I recommend that this bill ought to pass, and I'll take any questions.
Questions from the senators? Senator Long.
Thank you, Mr. Chairman. So my understanding, as in Manchester, is when the school has a no trespassing and it's election day and the school's being used for the election, that no trespass, that person could go vote because it's not school hours. Is that your understanding?
Thank you for the question, Senator. I think it's very unclear. It depends on how the no trespassing order is written. Does it have a carve out or not? You heard a testimony from another gentleman that he had to go get permission. I know there was a school board member that was no trespass and had to question whether she could go vote, and because the polls were at the Timberlane High School. So this bill actually helps clarify all that, there's limited circumstances that you actually have a reason. Right now, they're very terse and people don't really know. If some people can get a verbal no trespassing order, as you heard earlier, when does that expire? I can never go to the beach. So there's something that needs to be done with this. I think it is a big problem, and I appreciate your question.
Thank you.
Further questions from the senators? Seeing none, thank you very much. That is the last person who has signed up. And there were 2 in support and 43 opposed online. With that, we'll close public hearing. We'll open the next one in just a minute. All right, and with that, we'll open the public hearing on House Bill 1195. Please introduce yourself in the bill.
Thank you, Mr. Chairman. I'm Representative David Page, representing the town of Conway. Thank you for having me here this morning. Nice to see everybody. So New Hampshire needs roughly 10,000 additional childcare slots just to meet our current demand. But what does 10,000 missing slots really mean? It means 10,000 children in New Hampshire missing out on high quality early learning. It means thousands of parents delaying their return to work and their careers stalling out. It means businesses across our state struggling to hire because thousands of potential employees are out of the game. The cost to the Granite State is real. Millions of dollars in lost wages, millions in lost business productivity, millions in lost tax revenues.
Representative, if that's written statement that you're reading, we would much rather you pass that to us and then speak from your heart.
Happy to do that. So there isn't a single solution to the challenge. However, what we have here before us with HB 1195 is a targeted solution which is focused on removing local barriers that prevent new child care businesses from forming. It removes friction for home-based providers, and it makes it easier for child care centers to locate in appropriate commercial areas. And it does this while retaining strong state safety and licensing standards. I think that's really critical for everybody to understand. It also preserves key local oversight. So the barriers that we're talking about here aren't hypothetical. So one provider I spoke with spent 2 years and looked at more than 100 properties before they were able to find a property where they could open their center. And that wasn't because these properties were unsafe or didn't meet licensing requirements. It was because they couldn't navigate inconsistent local requirements. She had staff ready, she had the funding to open, she had more than enough families that were seeking care, right? What she didn't have was a viable location. And the way she put it is, if this bill had been law when I was searching, 2 years would have been 2 months, and 6 months of red tape would have been 6 weeks. So that's really the impact we're talking about. And this happens again and again around the state. Another provider I spoke with is ready to expand her existing child care center today to serve more families. She's located in a strip mall area. That strip mall area has a couple hundred parking spots that are underutilized. She has been held up in expanding her license capacity for her child care center to accommodate an additional 5 kids, 5 families, for months over a single parking spot, despite this huge surplus of parking in her existing location. So while this is happening, those parents remain out of the workforce. So this plays out every day all across the state. These local regulations can delay, discourage, or sometimes completely stop a child care center from opening. And this is happening at a time when 46% of households in the Granite State live in what we call a child care desert. So that's where there are at least 3 kids for every available slot in that census designated area. So that's the scope of the problem. And the folks we're stopping are, a mom with an infant at home who wants to take care of a few extra kids so she can have some income while she's taking care of her own infant in her own home, right? It's a business that wants to co-locate a small child care center with their business so that their employees have easy access to childcare where they work. These contradictory regulations prevent these very practical centers from opening. This bill doesn't solve everything. I think that's very clear. If we pass this, we're still going to have huge workforce challenges in the childcare industry. But where providers have the space, they have the funding, they have more than the demand they need, they have the will, the goodwill to serve our families and our kids, we really shouldn't be standing in their way. And if we're serious about supporting working families, serious about supporting employers, this would be a very practical place to start. So with that, I'll take any questions.
Seeing none, thank you very
Thank
much.
you.
All right, we're still going to be under 3-minute limit, except for the prime sponsors. And first on the list is Jacob Edwards. And please try not to repeat the things that we've already heard. You can say, I concur with, or something else, but you don't need to repeat. Thank you.
Hello, I'm Jacob Edwards. I'm a teacher from Salem, New Hampshire. I support this bill. I'll leave out a lot of what I was going to say because Mr. Francis Burke is here. I'm sure he's going to say a lot of what I'm already going to say because I heard a lot of it from him. So I had to take the day off. This is a surprise for me that I'm even able to be here, but I've had my eye on this. And it's such a problem with the modern world that, I'm a member of the Men of St. Joseph. It's a problem. So many families I know, with my sister, my brother, both of whom are in 2 working families, there just isn't enough daycare. It's expensive as anything. And it's a viewpoint problem where every business, there is a law about it, has to have ramps for wheelchairs. Every community has to accept handicapped people. It's inconvenience, it's an expense, but you have to accept it. There are other things like, details of farming or pet ownership where localities will make laws that say, well, we don't want you farming 800 pigs on your property in this area because that's a lifestyle thing. It's quite something that in the modern world, children are considered a lifestyle accessory that, some towns can weaponize laws to keep daycare out. It's crazy because it's the future of our society. For it to be treated like ferret ownership or whether we want to have pig farming here. No, daycare, every community needs children. There should be enough daycare, and that's all I have to say about it. I have no expertise about anything, but I'll take questions if anyone has any.
Questions from the senators? Seeing none, thank you very much.
Thank you very much.
Thank you, Chairman Gray and committee members. My name's Eric Power. I'm from Brookline. I also, in my 6th year on the Brookline Planning Board, I'm speaking in support of this bill. I think that we definitely hear that there's a lack of childcare in New Hampshire, similar to lack of housing. They kind of go hand in hand. And there are a lot of barriers. I hear about it. I hear it from others in the planning community. And this bill addresses that. There are requirements for childcare. They're in RSA 170-E and Health and Human Services rules. So that provides the guidelines to make sure that you're having reasonable childcare. But you should always be able to have a childcare in a residential location, being able to do that. Small ones, this is how we're going to solve the problem. And also, the bill also talks about allowing it in commercial areas. And that's also very important. So this is, a bipartisan bill. This bill is important for New Hampshire. It, there is a NIMBY factor out there. People don't want the child care in their town, but they want to solve the problem. But this really helps make that happen. And as a member of the planning board, I do support this. I hope that you will find this bill ought to pass, and I'll be glad to take any questions.
Questions from the senators? On line 6, what if I change by right to conditional use?
I would be okay with that, Senator Gray. It would be better not to, but I still think this would move the ball forward if you did that conditional use.
That would at least provide some local control, right?
It would provide a little bit of local control, yes. Thank you.
Okay, thank you very much. Seeing no other questions? Fran?
Good morning, Chairman Gray and senators. I'm Francis Burke. I'm here representing Cornerstone, a New Hampshire Christian support organization. Everything, I would reiterate all that has been said in a positive way. The economic impact, regulation is there. All of that is there. I would add that this provides for childcare that is closest to the family, and that's our interest in it. Many people are looking for childcare that's not institutional, that's not large places. And that's a real limitation right now with the existing system and how the towns are handling it. So we have some also concerns in the church area for home-based churches, so very small churches. There's some other regulations that allow the churches to do this kind of thing right now. We also see this as a backup if those were removed and the churches were not allowed to do this kind of thing on their properties. That's all I have to say. Thank you.
Questions from the senators? Senator Burke. Senator Burke has spoken.
We may not have a huge amount of things we'll probably overlap on, but this can be one of them. So I appreciate your comments. Do you view this as sort of a minor expansion of HB 1267 we passed a few years ago that allowed home-based daycares where they were regulated by DHHS to similar rules?
Yeah.
Thank you.
Yep.
Additional questions? Seeing none, thank you very much.
you,
Jay
Senator.
Cole? Cowell's? When you guys sign in, if you are a lobbyist, you are supposed to put who you're representing on the sign-in sheet. So just try to do that in the future.
How do you do? I'm Jackie Cowell. I'm representing Early Learning New Hampshire. We are a statewide nonprofit working to support childcare programs and the families they serve. And I am here in support of HB 1195. I am not a zoning expert, but but I am here speaking on behalf of Destiny Carter. She is not able to be here today, but she runs a program for about 20 children in Salem. And you've already heard Representative Page talk about her parking spot issue, but I'd like to read just a little bit more, and I am giving you her full testimony. The other thing that I very much appreciate about this bill is it came from the field. It came from the childcare community, looking to try to find any solutions they can. So I'm reading her testimony now very briefly, summarizing. My name is Destiny Carter. I operate a small childcare program licensed for 20 children in Salem. She urges you to pass HB 1195. She does currently have the physical space to expand. She could expand by 5 children whose families are on her wait list right now. They're desperate for childcare to be able to work. She says this expansion would generate approximately $8,000 for her in monthly revenue for her business and also allow 5 parents to return to the workforce. She concludes again by saying every day that her paperwork has been held up in her municipality is a day that 5 families go without care and her business loses the ability to grow. Thank you very much.
Questions from senators? Seeing none, thank you very much.
Thank you.
Trina Engelfinger? Came close?
Perfect. Thank you very much. I'm sending around some written testimony. I represent New Futures, a nonpartisan nonprofit organization working to improve health and well-being in New Hampshire. I am the Early Care and Education Policy Director at New Futures, and my work focuses on understanding the strengths and challenges in the childcare sector in New Hampshire. And one of the greatest challenges right now is that there are not enough slots to meet family demand. You heard others talk about the shortage. When we're talking about 10,000 slots short of the needs right now, that is if we were fully staffed in all of our childcare programs. And we're hearing about wait lists that would fill programs 2 and 3 times over in some cases. Childcare shortages depress workforce participation, so I just want to point out that there have been studies about the costs of that to the state, ranging between $150 and $250 million, and also studies recently that our young workforce are very concerned about childcare, and it may be an issue that is starting to cause young families to leave the state. Last thing I want to point out is that 2 of the most prominent national child care advocacy organizations are now promoting zoning reform as a way to build capacity at the state level. So all of that is in my written testimony, and I'm happy to take any questions.
Questions from senators? Senator Burton spoke.
Yeah, thank you. And thank you for being here. You just noted that there are wages lost, like you said, between 150 and 250 million dollars to the state's economy. Would you also agree with the statement that increasingly, in order to attract a workforce, all of the amenities around family building are increasingly important to attract our working families? You know, we're not talking about parental leave today, but like, you know, making sure there's opportunity to build your family, you know, send them to daycare, send them to a safe public school. Those are all pieces that are attracting our workforce.
Absolutely. Being able to raise a family and work in New Hampshire are 2 hand-in-hand critical pieces of our workforce for our businesses. So this is just one piece of that, but critically important. And we're seeing that in surveys and data.
A follow-up, if I may.
Yes, ma'am.
Would you believe that my children are 2, 4, and 6, and that when my 3rd baby was born, she was on a wait list behind 170 other children for a spot on the seacoast?
I would believe it, and we're seeing that in other places as well. Yeah, it's really complicated, and families are forced to make really unique and complex decisions about how they want to raise their families because we just don't have the infrastructure to support them right now.
Just one more follow-up, if I
Yes,
may,
ma'am.
sir. Would you believe, just anecdotally, in my sort of group of friends, I pretty much don't know a mom that hasn't struggled with, between sort of the parental leave and the childcare dilemma, being able to really work full-time.
Absolutely. And we don't want that to be something that drives people out of the state.
Yeah. Thank you.
Thank
Additional
you.
questions? Seeing none, thank you very much. Brody?
Thank you so much.
Thank you, Mr. Chairman, and thank you, the committee, for taking my testimony this morning. For the record, my name is Brody DeShays, and I represent the New Hampshire Municipal Association. So House Bill 1195 proposes to expand the recently established mandate under RSA 674:16 Roman 6, which currently requires municipalities to permit home-based care, family care, and group family care by right or pursuant to a conditional use permit as an accessory use to any primary residential use. RSA 674:16 Roman 6 has only been in law since September 24th of 2024 after the passage of 2024's House Bill 1567. So this bill is expanding the existing mandate for residential zones and also adding a new mandate for commercial zones. So for the residential, first, it would require municipalities to allow all home-based care, family and group family care by right on every lot with a primary residence, regardless of whether the land is zoned to permit commercial uses, and prohibit municipalities from requiring conditional use permit for a proposed home-based care or commercial use. Second, the bill would mandate that municipalities permit pre-existing accessory structures of any size for home-based care, essentially mandating that commercial dwelling units be permitted by right for any proposed home-based care. These uses and accessory commercial units would also be exempt from local site plan review where the primary residential use is permitted. So while the prohibition against site plan review already exists in the current law, what is currently required is only home-based care wholly within a residential dwelling unit's existing footprint. It is treated like an in-home business, like an accountant or a lawyer. So what this bill would be proposing is a whole new unit that could be completely separate, that's not wholly within a pre-existing structure, that could be of any amount of size that would have to permit these in-home based care that are no longer in a home. As it relates to the commercial zones, the bill would mandate that several different types of childcare centers be permitted by right in land zoned for commercial uses. It also prohibits site plan review regulations from being applicable if the licensed capacity of the childcare center will exceed 30 children. Even a childcare center that is licensed up to 30 children will have substantial vehicular traffic during busy commute times. I mean, you could imagine 45 to 75 vehicle visits per day for this commercial use. It's very atypical for a municipality not to require site plan review for a commercial use that has that much vehicular or pedestrian traffic, or to exempt it from lighting, drainage, and other public safety requirements. Both sections of the bill also override local zoning with state rulemaking developed by state employees, adding more complexity, not less, for applicants and municipal officials and employees and planning boards. These rules are written and drafted by folks who aren't municipal planners that would be overriding local zoning related to any type of ordinance and site plan review. I also have to flag, lastly, under House Bill 1195, there will be no entity regulating or ensuring all the public safety items and other things that are currently regulated under RSA 674:44 Roman 2, which you'll see is attached to...
Questions from the senators? Seeing none, thank you very much.
Thank you.
Natch.
Thank you. Nate Grays for the BIA. We support this legislation as it came over from the House. I'd like to address specifically the conditional use permit suggestion from Senator Gray on line 6. I'm sort of unclear about whether the suggestion was to retain the provision that would be deleted by right or pursuant to conditional use permit, or whether it would change to completely to conditional use permit. In either case, we would not be in favor of the change. For after the bill was passed a couple years ago, 1567, the CDFA paid the New Hampshire Zoning Atlas at St. A's to do a study on what changes needed to be done to zoning at the local level that still existed as a barrier to opening new childcare facilities. They identified about 12% of communities had conditional use permits. The problem with conditional use permits is they're very similar to site plan review, technically different, but very similar. And there could be different requirements in every zone for conditional use permits. So the goal of this bill is to create a level playing field to make sure that the barrier to entry to opening childcare facilities is the same. And it's really designed for to build upon the work on home base that was done a couple years ago by the legislature, and then for small center-based care in commercial zones, so downtown. So from a parent's perspective, if you are dropping your kid off down the street for the daycare with your neighbor, or maybe you yourself are opening one because you want to stay at home, or alternatively, you're driving downtown to work, you can bring your kid with you, drop them off at daycare there. So that's really the intent here, is to make both of those easy to do, and that's why we wouldn't want to create the opportunity for additional and different barriers, because many of these considerations that are part of the conditional use permits are geared towards child safety, and those are addressed in the rules that regulate the provider licenses, which they are not allowed to waive. So frequently when we see providers attempt to open childcare, if there are barriers in place at the local level, they end up, because for whatever reason they're scooped under zoning, they have to go through the variance process and get a variance because, again, they can't waive the state regulations, nor would we want them to, because those are aimed at child safety. Happy to take questions.
Questions from the senators? Senator Lyon.
So on its face, I don't disagree with the bill, but my question is, who deals with things like traffic safety? Like, how do you regulate if it's on a blind corner and
Yep.
it's going to create a vehicle hazard for people picking up and dropping off? How does a town regulate to make sure it doesn't put a hazardous condition in place?
Excellent question, Senator Lang. The department's here, I believe, but there are two specific provisions in the rules from the department that say that childcare providers have to train their staff to deal with traffic and other things that might endanger children where there's no physical barrier between the child and that traffic. So for example, at my daughter's daycare, they frequently go across the street to the public park, and they have to train the staff to make sure that they know how to take those little kids across the street in a safe manner that will result in them not getting hit by traffic.
Any additional questions? Yes.
Thank you, Mr. Chairman. And Nate, this may be a question for the department, but if I'm understanding your response to Senator Lang, is that there are conditions in licensing that if the physical location is an unsafe place, they wouldn't meet that bar for a license.
Right. Let me clarify. So when licensure occurs, the department comes in and does an inspection, ensures it meets all of basically building requirements for the building, for the playground, et cetera. What I was addressing, and I believed Senator Lang was asking about with traffic and everything else with corners, is what happens if a kid's outside the building because you're doing drop off and pick up, something like that, which may occur. So there are specific training requirements in addition to the building requirements that's within the licensure requirements. And the licensure rules are about 128 pages or so.
Thank you.
Additional questions? Seeing none, thank you very much.
Thank you.
Drew Klein.
Morning, members of the committee. Mr. Chairman, thank you for having me. Drew Klein, president of the Josiah Bartlett Center for Public Policy, New Hampshire's free market think tank. We very much like this bill and all of its, both of its provisions. That's for residential as well as for commercial. I'll address the residential first. We think it's perfectly appropriate to have it by right, and to have it by right for the ADUs, conditional use permits. obviously, are traditionally to allow things on a case-by-case basis that aren't traditionally done in that setting. But childcare is traditionally done in residential settings. It historically has been through all of New Hampshire, all of American history, all of world history. Regulating it out by the zoning rules is relatively new, and it's been one of the factors in causing our childcare shortage. So we would strongly support it remaining by right. Even at the ADU, remember these are existing ADUs. And also, just to be clear on what this allows for the residential, it doesn't allow any childcare size. It's only the two smallest, right? So it's only a 6-person or a 12 child. So it's not massive daycare centers. On the commercial side, one of the issues with the shortage of daycares in New Hampshire is not just the numbers, it's where they're located. So about mid 70s percentage of women in New Hampshire are in the workforce. When it comes to prime working age, 24 to 54, I think it's about 84%. And one of the biggest problems is the mismatch in location from your home to where you want to work. And allowing it by right in commercial centers, as this bill does, I think would really open up a lot of opportunities to match daycare provision where people work, which is really important. So what you're getting now is daycares sort of segregated in one area, maybe out of a town entirely or in a different part of town. And so the parents have to do this long triangulation to drop off the kids, pick up the kids. What this bill does is basically create a situation where it's much more likely that you're going to develop those daycare centers where people are actually working. And I think that's really important. There aren't a lot of bills in New Hampshire, 1,000 bills a session, that if you pass, you would probably see a pretty quick response in the marketplace. And now, granted, it takes time to get approvals and all that kind of thing, but I think within the next few years, this will be something you would see a good response in the marketplace too.
Questions from senators?
Thank you for being here. As I mentioned previously, this seems to be an expansion of the bill we worked on a bipartisan basis to allow daycare by right in residential zones. Have we heard any stories or anecdotes about those causing traffic problems or sort of creating any zoning issues?
Not that I've heard, but I don't know how many you've gotten at this point.
Yep. Follow up if I may.
Yep.
And as you mentioned, would you believe that the only daycare that any of my children has ever been admitted to is a 45-minute round trip from my house?
I think in some cases, you'd be lucky to have a 45-minute round trip.
Thank you.
Yep.
Additional questions? Seeing none, thank you very much. And from the department, Ms. Clement.
Good morning, members of the committee. My name is Melissa Clement, and I'm the Chief of the Child Care Licensing Unit for the Department of Health and Human Services. We're neutral on the bill. We're not supporting either way. I'm here to answer any questions you may have and to just try to provide where we come into play when it comes to licensing child care programs. So under RSA 170E:6, it is required that we have local approvals for childcare programs. Those local approvals include a health officer inspection, a fire inspection, and also zoning approval. So those three things are needed before license can be obtained by our unit. So we go through that process first, then we go out and do our inspection based on our licensing rules, which are HEC 4002. And then provided they meet our licensing rules with those approvals, we issue a license. And with that, I'll just leave it to you to ask any questions that you may have. Thank you.
Questions from senators? Senator Rhodes.
Thank you, Mr. Chairman, and thank you for your testimony. And as I understand, the RSA is in 170E and the rules in 4002. they are very extensive and very thorough. Unless they've changed in the last 10 years, I've been through
They
this
have changed,
process.
yes.
But regardless, they're fairly comprehensive in what
Mhm.
they look at. Am I wrong in that assessment?
No, you're not. We just recently revised them as of September of 2025. So if you haven't seen them lately, we do
I haven't
have
seen
some
them
new
lately,
ones.
but very good. Thank you.
Sure, you're welcome.
Senator Lang.
So again, my question, it revolves, I guess, basically off-site, but related to issues, things like roads and how. Is that covered anywhere in your provision? If pickup and drop-off is problematic, is that involved in your licensing at all?
No, it is not, and thank you for the question. So our rules revolve around once the parent has relinquished custody of their child to the child care program, then the child care staff are then responsible for the children. So when it comes to parking lots or those things, when the parent is with the child, it's the parent's responsibility for bringing that child safely into the program and having them with the teachers. Once the parent has done that, then as mentioned, I'm sorry, I'm going to forget his name, we do have rules around how staff need to supervise those children and take into account the traffic where they are transporting children if they're taking walks or something off their property. On their property, we would look to fence in any unsafe areas so that they're safe from traffic.
Additional question. Senator Perkins. Okay.
Thank you. This is a question relying on my memory, so it may not be entirely accurate, but I do seem to remember there was some element of your rules that maybe did concern parking. Is that correct? Or
I don't want to say verbatim without having the rules in front of me, but I
Yeah.
can certainly get back to that with you with that information. We do have rules around when it's a school age program located in a public school
Yeah.
that we can't tell the public school that they have to fence off certain things. You know, we don't have the authority for that because
Yeah.
in our statute, we draw a line between public schools and what they can do on their property. So what we say in lieu of being able to do any more permanent protection for children around traffic, that staff are trained in making sure that children can be watched safely while handling the parking lots and any sort of traffic that may come from pick up and drop off in a public school setting.
Sure. Follow up if I may, Chair. That said, we're, again, as a reminder, we're talking about daycares that handle up to 6 or 12 children. So we're really talking about, potentially 4 or 5 cars that come by in the morning. And then the ratios are regulated in terms of how many educators or home-based folks are there. So we sort of know that this is a small amount of traffic from the outset.
I would agree with that for those smaller programs that are 6 to 12, absolutely. But I also want to remind you that when the parents are with them, the parents are responsible for the drop off and the pickup,
Sure.
not the child care staff.
Yeah, sure.
I don't
No.
want to give the impression that child care staff are watching the pickup and drop off procedure.
No, I want to speak to the interaction between the site plan review and the traffic and the, sort of regulation of these daycares. Just one more question, if I could.
Absolutely.
Chairman. Do you find that some of the folks starting these daycares, they may know everything about what to do in early education and how to handle a child, but they may not be super familiar with a planning board process or the licensing process, but they're trying to start a new business to sort of help fill this need?
Yes, I would agree with that.
Okay, thank you.
You're welcome.
I don't want there to be any confusion in the home setting. Yes, we're talking about the lower limits, but in a commercial setting, what would the limit be?
For the number of children who could be there. So that would be dependent on their square footage in the physical space. So there's 35 square feet, and that's consistent with the life safety code as well per child. So that is what the limit would be outside of any prohibitions placed for other reasons at the local level.
Additional questions from any of the senators? Seeing none, thank you very much. And with that, there were 2 additional people who signed up, did not wish to speak in support. And the online signups were 63 in support, 4 opposed. And with that, we'll close the public hearing. We'll start the next one in just a minute. Thank you. It looks like we're ready, so go ahead, Representative, and introduce yourself in the bill.
Thank you, Chairman Gray and honorable committee members. For the record, I'm Bob Wary. I have the privilege of representing Hillsborough District 13, the great town of Hudson. House Bill 1213 concerns the implementation of highway agents, also road agents, and the contracted version of them, which is expert agents. In dealing with the RSAs involving these, there's several variables. It's the election variable, the appointment variable, the contract variable for the expert agents. There is also the number of highway agents that's a variable, and the duration of their service in terms when it's an elected or appointed position. So all this does, and I've outlined on the testimony a table to kind of outline how this bill addresses each of those. It's really trying to control those 5 or 6 variables that I just mentioned, and trying to really provide a little bit more clarity to what is there. So once you grasp the 5 variables and what is involved, the bill is actually pretty straightforward. It does clarify a number of things, and so I'd be happy to take any questions at this point.
Questions from the senators? Senator Lang.
What are we trying to solve here?
So the New Hampshire, let me just, New Hampshire, A Hard Road to Travel mentions that in dealing with highway agents and some of this, there are certain aspects that are unclear. The law, I'll quote right here, the law is unclear regarding the difference between appointed agent, appointed expert agent, and goes on and on. So there is some published testimony, if you will, that there are some unclear aspects of this law. So, and I think it has to do a lot with all the different variables involved. So this is really just trying to outline how each of those variables can get addressed in a manner rather than trying to kind of make it up on the spot or try and sort it out of one's own volition.
Follow-up?
So why would we make, in all the towns I've been in, the road agent's never been a 1-year term. It's been a multi-year term. A little hard to get someone to hire and then have a consistent road plan for a road agent who's only there for 1 year, and then the plan decides we're going to shift over to here and leave that project half unfinished. And is there a reason why you've chosen 1 year, not a multi-year term, to be able to plan?
No, it allows for multiple years. It's not a I don't believe it restricts it to 1 year.
Well, defaults to 1 unless the town decides by a majority vote to change that arrangement pursuant to the other A agent, which is, I think, the number of agents, and then the 3 section is the expert agent.
Right. I think I see over in the second page, I mean, this talks about 2 or 3 years. So, I think I don't think it restricts it to just 1 year. I guess that's what but there are some who, I mean, if you think 1 year never belongs, then I'm happy to have you amend it.
Senator Rushford has a question.
Thank you, Mr. Chairman. With the exception of this time of year, I think our roads are our road agents and highway agents and our road crews do a pretty good job maintaining our roads. How will our roads be improved if we pass this bill?
So, well, one of the, as towns expand and more additional roads are added, I think this gives a little bit more flexibility to, if a town crosses a certain threshold where they feel that there's more work that needs to be done, or perhaps in a particularly hard winter where you may want to appoint an agent for just a year and appoint an additional agent so that additional repairs can be made, it would address that sort of opportunity.
Follow up. As I understand, in my town, on tough years like this, they just hire more part-time guys and they get the roads done, and I'm able to get here on time. I'm struggling with the need here. I'm looking at the, how this will improve our roads, or if we don't do this, how our roads will decline.
It's a good question. I think it's a matter of just making the process of implementing them more clear.
Thank you.
It's the agents themselves who take care of the roads, not the law. So,
Any additional questions? Thank you very much.
You're welcome.
You didn't sign up as to speak. Do you want to speak? Okay, Eric.
Good morning, Chairman Gray and the members of the committee. My name is Eric Power. I'm from Brookline. I serve on the Brookline Planning Board, and I'm in support of this bill. I also served in 2017 to 2018 on a chartered study committee to look at transitioning our road agent to a public works agent. And in that process, I talked to a number. I was the chairman of the committee. I talked to a number of towns that had road agents and highway agents, and just came across a lot of challenges. One of the number one challenges is what is an expert agent? And everybody seems to want to have the expert agent. The expert agent is when you have one highway agent, and that person is appointed by the select board, and that person is responsible for all the roads, and they can hire a staff. They can be paid whatever salary, and that person serves at the pleasure of the select board. Now, currently, in towns, there's a lot of options there. You can have appointed agents, you can have elected agents, you can have 1, 2, or 3 year terms. And it's also very confusing. There's actually, in the 1970s, you might be aware of this, in election law, there was about 15 laws that made a difference on how you vote for these based on how large the town was. 4,500 was the number. And slowly over the years, they've all disappeared. Last year, the second to last one had to do with partisan municipal elections. That disappeared. This is the last remnant of calling a large town 4,500. So that's how you vote on these, is depending on whether it's a large town or not. It's kind of arbitrary now, I think. So this bill streamlines that and says we're going to use the official ballot for any actions on road agents. And that would allow the select board to, either you would elect the highway agents by the voters, or you could enable the select board to appoint them. You could do a 1 year, 2 year, or 3 year term. It doesn't change the current law in terms of the default being one highway agent for 1 year that's elected. But the town can change that, and this really clarifies that. It streamlines and standardizes the process. And I think the most important part of the bill is the clarification of the expert highway agent, that it serves at the pleasure of the select board. And that's been very unclear. And in the handout, there's this hard road to travel sheet. And if you look on the back in the middle, it says their law is unclear regarding the difference between an appointed agent and an appointed expert agent. So that's the major problem. And it's caused lawsuits. It's caused spending on lawyers that doesn't need to be happening. And this bill would help avoid that. I think from my experience in talking to a lot of the other towns, peer towns, they would like to go to the expert agent, but they would only go there if if the law was clarified that it would be an expert agent and it would be at the pleasure of the select board. And I have more details that I handed out. You can read them. The last handout is just the current law. You can see it's a little bit confusing. This simplifies it. So I think it would lead to better maintenance of roads and more efficient operations in our towns for their highways. Thank you very much.
Questions from the senators? Seeing none, thank you very much. That is the last person who has signed up and wished to speak. There were 2 other people who signed up, one in support and one opposed. In the online, there was 1 in support and 10 opposed. And with that, we'll close public hearing, and we'll open the next one in just a minute. Representative Dunn.
Thank you, Chairman Gray. Good morning, Chairman Gray, committee members. I'm Representative Ron Dunn from Londonderry. I'm here today to sponsor this bill that would change the way we calculate the default budget here in New Hampshire towns. A default budget in simple terms is based on the previous year's operating budget with adjustments for debt, contracts, and other obligations. The default budget has been a topic of discussion for many years in New Hampshire towns. No one seems to like the way it operates, but no one seems to find a better way. This bill takes issue with using unfilled employee positions to fund other areas of the budget that would eliminate this practice. An example of this issue that this bill would fix would be using unfilled positions to fund other areas of the budget. Departments will not hire unfilled positions, so they can use this money to pay for other areas of the budget that may be underfunded or overspent. This practice needs to end. If this position is needed, it should be filled. If not, it should be eliminated. When residents go to the polls to vote, they are voting on what they want in the budget. They are not saying that the department heads, it gives them a slush fund or allows them to overspend their budget, or allows towns to spend on other things that residents may not have wanted in the budget that wasn't included. This practice can lead to inefficiency and wasteful spending. It also leads to lack of trust and transparency in government. The fixes I'm proposing in this legislation will not solve all the problems with the default budget system, but they're moves in the right direction. The default budget is complicated. It needs to be fixed and reworked. This is a one step in the right direction to fix a broken default budget system. Thank you for your time this morning. I'll take any
Questions from the senators? Seeing none, thank you very much.
Thank
Again, you didn't say whether you wanted to speak or not. All right, Representative, come on up.
Very much. Thank you, members of the committee. Again, Juliet Harvey-Bullia from Belknap 3, just speaking in favor of this bill, and if support ought to pass as a way to, I've heard a lot of complaints about the default budget, and any fixes we can do will help. Thank you.
Questions from the senators? Seeing none, thank you very much. Brian? And just to remind everybody, we're on a 3-minute timer.
Okay, I'll accept the challenge. For the record, Brian Hawkins representing NEA New Hampshire. We represent teachers, paraprofessionals, aides, school bus drivers, all sorts of staff that help support our students. And we're here in opposition to House Bill 1224. We think that this bill will make it harder to hire and have far-reaching effects that maybe are not being thought through here for this bill. Also, as the governor mentioned in her veto of a very similar bill, that it's an unnecessary overreach by the state into municipal and, in this case, school affairs. There's the added exemption for just public safety. I won't touch too much on that, but notice that it is not apply to schools. And then the last point I'll make is that, we're under a shortage in many very critical areas that are difficult to hire these days. For those of you who've spent some time on the Senate Education Committee, you know that. The latest shortage list I encourage you to look at, but it includes positions such as chemistry teacher, computer science, several math categories, special education, reading and writing specialists. And so these are critical positions, and if a school district is in a position to finally make that higher, we wouldn't want the default budget, this change in the default budget to prohibit them from doing so. And with that, I'll close my testimony. And
questions from the senators? Seeing none, thank you very much.
Appreciate it, Mr. Chairman.
Hello, Chairman Gray and members of the committee. My name is Eric Power from Brookline, president of the School District Governors Association of New Hampshire, speaking in favor of this bill. Default budgets are a big problem in New Hampshire. They're a big challenge. DRA, when I've contacted them, they say that's the number one question they get every year, questions about default budgets, what needs to be in them, what doesn't. This bill really makes it clear that if you have long vacant positions, they're not going to stay in the default budget. The default budget is supposed to be your bare bones basic budget. And if you can't just have empty positions there year after year. You put them in the proposed budget if you really want the voters to support them. So that's the important thing. So if they're over a year old, they're not in there. We'll talk about some exceptions in a second. If a position has been filled, you use the actual salary and benefits of that new position. We had a senior library director retire, but in the default budget, we had to have the high number, even though it was a younger person that had come in at a much lower salary. The default budget had to have the $100,000 salary, not the new $55,000 salary. This would correct for that. And it also corrects for the one-time expenditures. When things are transferred around on one-time expenses, those should not be staying in the budget. They were used for one-time expense. One-time expenses are excluded, so this makes it clear. And it also there was a loophole about previously incurred by law or required by law, and that was being used to justify expenses that were sort of done by preference, not really by law, by the way the language that was in the law. I'd also like to mention from a school district perspective, if you have special education vacancies, and those are actually required by law, so those would remain in the default budget, but other positions would not. And I've also seen, here's an example from Derry School District this year. They had a proposed budget of $113.4 million, and they had a default budget of $113.7 million, and the difference between the two budgets was only 0.3%. So, and they had actually lost 1.5 students, and that budget was up, depending on which budget you look at, either 8.8 or 9.1, with the student cost going up 10.3%. The default budget is not supposed to have built-in padding, built-in contingencies. There are separate warrant articles that can be used for that purpose, so the voters can approve each year if they want a contingency fund or not, or they want to retain a fund balance. Those are the ways to do it, not by putting in empty positions and then transferring them and using them for other purposes. And there is a carve out, because this is the same bill, almost the same bill as House Bill 475 that this committee passed last year, has a carve out for public safety positions. If you're using the money for those can remain, those vacant positions can remain in the budget. The money can be used for overtime, or it can be used to cover contracted personnel for those purposes. And if it's not, it gets returned to the voters. This will go a long way to making default budgets really a basic budget, and I hope that the committee finds this ought to pass, and I'll be happy to take any questions.
Questions from the senators? Seeing none, thank you very much.
Thank you.
Brody.
Thank you, Mr. Chairman, and thank you to the committee for taking my testimony this morning. Again, for the record, Bertie Deshays, I represent the New Hampshire Municipal Association. I've just passed around some written testimony. So I'll be brief and just cover the key points. So first, I really want to stress the default budget is not supposed to be a representation of a bare bones budget, or necessarily always even equal to the previous year's budget. It reflects the previously approved budget with certain contractual obligations adjusted. So to make sure that the municipality, school district, whatever political subdivision has adopted the provisions of SB2, RSA 40:13, and effectively so then they can make good on their contractual obligations. And seeing as they're voting by ballot on the budget, there's no way to have amendments at the second session to the budget if it fails. So there is an option for municipalities to have a special meeting, but most just go with the default budget if they've adopted SB2. First, House Bill 1224 impedes hiring, especially for key but difficult to hire positions. It can be very difficult to hire for positions in the current labor market. Sometimes municipalities need to keep these positions open for multiple years, and sometimes they need to make line item transfers to increase the salary or the pay for those positions to attract good quality workers. It interferes with the select board's normal management decisions regarding employee salaries and benefits. Again, the select board has a fair amount of latitude, and it's under their authority to be able to determine where
salaries should be set and to meet certain, wage needs for what the labor market is demanding. They do wage studies, and they might find that a position that has been open for multiple years, that's only been appropriated to a certain amount reflective of a budget from 2, 3, 4, even 5 years ago, that they need to make adjustments to that salary. Additionally, House Bill 1224 misconstrues the purpose of line item transfers and creates more ambiguity and administrative burden in the calculation. Any one-time line item transfer would have to be removed from the default budget under House Bill 1224. This really would prevent municipalities from having the flexibility in their select boards to meet ongoing fiscal needs. And when they have extra money to meet needs that arise maybe mid-budget cycle, they would effectively be having to forego these one-time line item transfers to address those things. Otherwise, they would lose out in their next budget. It also directly contradicts the existing RSA 32:10 Roman 1b, which states neither the Budget Committee nor other citizens shall have any authority to dispute or challenge the discretion of the governing body in making such transfers. So it's recognized that just like department heads in the state, the select board needs some ability and flexibility and optionality to address the town's fiscal needs. And I'd be happy to conclude my testimony and answer any questions.
Questions from the senators? Seeing none, thank you very much.
Thank you.
There was one person who signed up, did not wish to speak, in opposition. And online, there was 5 in support and 26 in opposition. And with that, I'll close the public hearing.
Move to go into executive session.
We have a motion to go into executive session. All those in favor say aye. Aye. All those opposed say nay. The ayes have it. We are in executive session. All right. For older bills, we still had a few that we didn't act on. My stuff has gotten all mixed up here, so.
We can start with 1601.
1601 sounds like a good one to do.
Here we are with this one. It's the voter education $50,000 allotment. I think Senator Perkins Cloco was looking for some information from the Secretary of State's office.
And I provided that list to, did I provide it to you or to the whole committee?
I don't remember seeing it.
You got it, right?
I did Chairman, I did a little sleuthing, and my aide talked to your aide and discovered the email that you had. So I have a copy of it, but I don't know if anyone else does. That said, it satisfies the questions I had about this.
It could be in my sent or unsent email in my outbasket.
Could be.
Sure. So why don't we set that one aside for a few minutes while they make copies? Yeah, make
So I'm guessing you're interested
10.
in Senator Perkins Cloco's take on it.
I thought it was helpful. What I was really looking for was sort of a summary of the efforts that the Secretary of State was making, because I think the question was just sort of what is happening now. And I know I have a colleague on this committee who felt like a lot was happening and shares some of that information. So I think it was just good to kind of see that laid out and be able to share it with other parties.
I do want that list to be part of the record, so.
Okay.
If we hold off on this one until he comes back with that and then bring it back up. The other one we had was 1604, and that was public facilities made available for the polling places. Personally, I think that this still has a lot of things that I would question. Comments from you guys?
I would agree. I think that this is this bill was designed for one specific issue, one specific town, and without a major amendment, I don't see this going forward.
I'll move interim study.
Second.
Motion for interim study and a second. In my experience, that if a city or town has a school that they want to use, that if sufficient notice is given, it's not that hard to schedule a teacher's workshop or something else on that day where the students would not be in the building, which resolves a whole lot of problems. But that's not what the bill does. Is there any other comments before we vote on the motion of interim study? Okay. Seeing no other comments, all those in favor of interim study say aye.
Aye.
Aye. All those opposed say nay. The ayes have it. And is there a objection to consent? Seeing none, all those in favor say aye.
Aye.
And
I can take this out.
send it along. Okay.
So, Mr. Chair, I'd like to work, so we don't take it up, I'd like to work on 1184, the NTO bill.
Okay.
I think there's some possibility there, but let me see if I can work it out.
Senator Lang
I'd ask us to hold that.
to work.
On HB 1213, is this committee ready to act?
I'm ready to act.
I'm ready to act.
I got the sense you might be, Senator Rochefort.
You want to make a motion? I will. I'll make a motion of ITL.
Second.
Have Horsford and Lang motion of.
Would you like to speak to your motion?
I think I've said it all. I don't think it's needed. I don't think it's necessary. I don't think it will improve our roads. I don't think passing it will result in a decline in our roads. And that's all I have to say.
Additional comments? Seeing none, the motion is ITL. All those in favor say aye.
Aye.
All those opposed say nay. The ayes have it. Is there objection to consent?
Nope.
Seeing none, all those in favor of consent say aye.
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 And Senator Rochford, you got that one. All right, we all have the list for 1601. I guess I would move interim study on this one.
I'll second.
Now, it has been my observation over the 14 years that I've been in the legislature is that you're not going to satisfy everybody. There's always going to be somebody out there that says, you never told me. I never knew.
I'm shocked, I tell you.
And certainly the list, and again, that's why I wanted to correct my apparent error in not sending it out, get it into the record, but there's a page and a quarter here. It is double spaced, but of things that they're already doing. So with that, is there any other comments? The motion is interim study. All those in favor of interim study say aye.
Aye.
All those opposed say nay. And is there objection to consent? Not seeing any. Then all those in favor of consent say aye.
Aye.
And I will take that one out. All right, any of the other bills that we heard today that you want to speak to?
1195.
1195, the child care one.
I'm not making a motion. I'm inclined to say OTP. My only concern around this bill is public safety, in terms of road access and egress and ingress and control of that. Other than that, I think by default they should have the right to be able to have it. I think it will help solve our childcare problems, but I'm a little nervous about ingress and egress and onto public roads and how that's managed. That was my only concern with this bill by making it by right. And I don't know how we deal with that.
Yeah, so if I may, Chairman,
ma'am.
I detected that hesitation in the hearing. So I have asked some of the supporters of this bill to reach out to a traffic engineer who can kind of talk to members of the committee. Maybe that would be helpful if they could give you a call, because I think the intent here is for this to be sort of de minimis disruption to the traffic. And I don't think it's an invalid concern at all, but I also just don't want to put an entire planning board process in front of small businesses when they're just trying to get open. So if we can address that concern some other way, I think it's valid, especially in places like Portsmouth where it's congested. I want to make sure we're checking all the boxes, but I just want to do it in as simple way as we can.
I mean, I asked some of those questions.
Yeah.
It doesn't change my bullish nature on this bill.
Yeah.
I think that, we were reminded that these are not 30 kids, 50 kids, 100 kids. These are in-home facilities. And I'm reminded about the traffic at my house with a house full of teenagers on a Friday or Saturday night. And there's a lot of in and out there, coming and going. And, if the parents feel like that is not the appropriate place and they're nervous about it, I feel like either they would choose not to do it, or they would, ensure that they're taking proper precautions. So I'm still bullish on this. I don't want to see that derail this. I feel that this is a big need, and but I'm happy to talk to someone.
And if I may, I also want to just point out that on page 2, lines 17 through 19 of the bill, which I actually think might address the concerns as well, but nothing in this section shall be interpreted to prohibit the child care center from being subject to local site plan review if the license capacity will not exceed 30 children. So, in other words, there's sort of a cap on the number of cars that are coming and going set out here.
Mr. Chair, I'll move OTP.
Second.
We have a motion of OTP. Senator Lang, and by Senator Rochford. In the hearing, I did, talk about changing it from by right to conditional use, but I'm really concerned more not in the R1, R2 setting, but in the industrial setting. And I think that if you drop that number that you were talking about on page 19 down so that it exceeds the home capacity, and that would be 12.
Yep, the home capacity is 12.
That does, take my concern away. So if you to get to by 5 numbers, if that 30 went to 15, I would be happier, but I want to get your guys' opinion of that before I would try to make a committee motion.
I'm personally not inclined to change it, though I always appreciate the opinion of my chairman, but maybe you could elaborate a little bit what is concerning you, because I tend to think there's a very practical protection around these being located in industrial zones, which is that they're not going to open in a place where kids would sort of be unsafe or exposed to something nearby, because parents aren't going to go there. There's a market-based concern. So maybe I'm not hitting the nail on the head, though.
If there were other things that are authorized by right in an industrial zone, okay, the planning board may know about some of those things when somebody's trying to locate. And so, if there was heavier truck traffic that was, right next door or other things, certainly that would be a reason not to do it. But if that use changed afterward, then certainly the planning board would be able to handle that in the change of use. But if it was the prior use, but accelerated, it may not be the part of the planning board to do that. So I'm still trying to get the local control in the industrial areas where these numbers are going to be higher. I'll even split the difference with you and give you a little extra and go to 20. I mean, but I think that does need to be, that, again, for residential use, you know, where I'm just doing
Sure.
the 6 to 12,
Sure.
I'm fine with that being allowed by right. But in line 19, I'd like that number lower than 30. But any other comments?
Yeah, if I could.
It doesn't sound like it's supported, so.
No, it makes sense to me. I mean, 20 would, in my mind, be a good number, because I do have to agree. An industrial area where there's a trucking company, there should be some oversight to that. It should not be left blank. So 20 would be a fair number. What is it, 35 square feet per child?
I think that's what they said, yeah, or 25, yeah, it's,
Okay,
yeah.
so I think that would be fair.
I'm gonna do a little math. Okay, so that's only 700 square feet, which means if you're gonna open this sort of small childcare,
Be less than 24 by 32.
right? You know, what concerns me is not having to have a little oversight on this. I think that's could be a good thing, but it's that now, instead of just being able to sort of move forward, lease a space, get your license, you now have to have a whole separate set of expertise on your team. You have to incur the cost to go in front of the planning board. I mean, again, I'm not sure that a daycare would locate itself around lots of heavy trucking activities. So I could go with the will of the committee, but I'm inclined to leave it as is.
I mean, I think if we went from 20 or 30 to 20, the rest of the bill is in place. I'm kind of thinking that's 20 families now that have childcare.
Or 10.
Or
because
10.
they're
Or 10.
sibling.
I mean, even at 10.
Yep.
And, the testimony of Mr. Klein really, he did highlight the fact that most of the stuff is in homes. This, and it's traditionally been in homes. This is geared towards homes. I could be arm twisted into 20.
So my take is that commercial, industrial, manufacturing, the town's already made some determinations in and of itself as to what's allowed and not allowed and traffic expectations for those. So I'm not sure I'm there at changing it to 30, from down to 20. I'd do it as a compromise if it moves the bill forward. But my inclination is that when a town votes zoning ordinances in, it takes into consideration it's a commercial zone. We expect we're going to have more traffic than an R1 or an R2 zone. And so they've already kind of addressed most of those concerns, I think, in their decision to make it that kind of zoning location. So I don't know if that's any benefit to reducing it, because that'd be no difference than having 30 people show up at a store, right? And they've already accounted and allotted for that. So
The distinction in my mind is the by right. Okay. And when you put by right and you put this in there, yes, it's by right, but they need to come in front of the board, whether it's 20, 30 or whatever. What I probably would like to do is to get the motion rescinded and let you think about it for a week and see if we can't come to more unanimous conclusion. Or do you want to go ahead?
trying to be nice to the chair. But I'm okay with the bill the way it's written.
Don't worry about the chair's opinion.
I'm okay with the bill as written.
I guess my thought is, if we pass it as is, we pass it as is. It doesn't get held up in a committee, a conference.
Okay, the motion before us is ought to pass. All those in favor say aye.
Aye.
All those opposed say nay. Nay. It's 4-1.
I'll pick it up.
I don't have objection to consent. Does anyone else? Okay, all those in favor of consent say aye.
Aye.
All those opposed say nay. And
I'll take it out unless Rebecca wants it. I'll give it.
No, doesn't matter to me.
Senator Lang. Okay. What else you guys want to talk about?
1224, default budget conversation.
1224.
I'm going to move interim study.
Second.
24.
All right, I don't disagree with the interim study, especially with the things that we did about the default budget. Going, if there is a budget committee, to the budget committee.
Yeah.
I think that needs some time to work itself out.
Yeah.
Any other comments? The motion is interim study. All those in favor say aye.
Aye.
All those opposed say nay. The ayes have it. Is there an objection to consent? Seeing none, all those in favor of consent say aye. Aye. All opposed. And who wants that one?
I'll take it. I made the motion. I can take it. Oh, no, give it to Pat. I'm happy with that.
Keep Pat busy. All right.
Keep Jessica busy.
Well, Jessica's getting pretty good at writing these things.
She's very good at writing those things.
All right. Anything else you want to do?
I don't think we got anything else to do.
Okay. With that, I'll take a
Move to
motion.
come out of executive session.
Have a motion to come out of executive session. All those in favor say aye. Aye. All those opposed say nay. The ayes have it. Our business of the day being complete. We are adjourned.
Mr. Chair, when are we planning on, what do you think